record. Yeah, there we go. So welcome everyone. This is the first of the calendar year 2025 meeting of the Tort Law and Social Equality Project. And I think we have the perfect person to kick us off for the year. Jane Thomson, who, as you just heard, is a associate professor at the University of New Brunswick Faculty of Law. And to my mind, Jane is one of the leading thinkers about the relationship between private law generally and social justice issues, and especially from a Canadian context and its manifestation in Canadian legal doctrine. Um, Today, she's going to be talking about the doctrine of public policy and discrimination in private law, small light in an era of darkness. And so this talk, so a lot of Jane's research and writing is on wills and estates, so kind of tort law adjacent. So we're taking a bit of a detour through, I guess, property law in order to see how public policy manifests there, to be able to see how it might be of use in tort law. And I'm sure Jane will touch on that point. So we can just get started. Jane, feel free to take it away. Hopefully you all
Hey,
can see the slides. Okay, thanks.
also, hopefully I can work the slideshow. We'll see about that. No promises.
I'll say, Jane,
Okay.
we usually go for 45 minutes, but like give or
Yeah,
take. I'll keep it. Okay.
I'm hoping to keep it to that.
Okay.
Okay, well, thank you so much, people tuning in from all these different places. I sat down to write this presentation in late November, and that's the darkest time of the year, right? When it gets black by 5 p.m. and you feel tired all the time. So writing this presentation in darkness made me think about light. And I have to admit, I've always been a big fan of fantasy novels, and several literary examples of light in times of darkness helped inspire this talk. One of them is from Lord of the Rings. Okay, so it's that part in the novel where the elf queen Galadriel makes a gift to Frodo Baggins. Now, for those of you not familiar with the novel or the movie, Frodo's a hobbit, and he's one of the smallest and weakest creatures on Middle Earth. And yet he's tasked with this impossible mission of saving it. And the gift that Galadriel makes to Frodo is called the Light of Arendel's Star. It's a little vial of water in a small flask, so small that Frodo can wear it around his neck. And when she passes the gift to Frodo, she says, "May it be a light to you in dark places when all other lights go out." Often when things go politically awry, at least for those of us who believe that the role of governments is to protect the vulnerable and not exploit them, we look to our courts as a safeguard. In Canada, our first instincts are usually Charter of Rights and Freedoms or the Quebec Charter, perhaps our Human Rights Acts, and those are good instincts. But sometimes the current of discrimination can run so deep that it takes hold and it blooms in places where those safeguards cannot go. And those who seek to keep harmful discrimination at bay in the deepest crevices of the private law have to rely on private law tools. And one of those is a tool that exists both in the common law and in the civil law, the doctrine of public policy. I often think about that passage from the Lord of Rings, about a light in dark places when all other lights go out. Because public policy is a light that is lit by our deep core values as a nation, things that our institutions and our multicultural democracy rest upon. It's not easily extinguished, no matter how small its flame might be. And today I want to talk about what I see as a unique use of this doctrine, both in its common law and its civil law codified form, by Canadian courts to manage discrimination in the private law, specifically in the area of wills and trusts. Now, when I say manage, I mean that not all instances of discrimination in the private law have been voided or should be voided following an application of public policy. In a way, this area of the law functions much like applications of the public law. That is, a balancing of interests take place, just perhaps done so less clearly, as if through a glass darkly, something that Justice Walter Tornopolsky wrote about many years ago, and I'll try to explain in this talk. In doing so, I'm going to point out what I think are proper applications of the doctrine, but also some concerns I have about other applications that perhaps lack transparency or proper justification, because I fear these latter applications may weaken the flame of public policy for future uses. Now, I understand this group's focus is on tort law. It's not my field, but as all of you know or should know, the doctrine of public policy has been used to champion torts in the past, particularly the tort to combat discrimination, right? The case of Beduria being at the forefront of this battle, and it will certainly have future roles to play as well. So this talk really isn't about wills and trusts so much as it is about how courts employ and apply the doctrine of public policy to combat discrimination in the private law. I'm going to talk to you about the cases in Canada. I'm going to review some of them in greater detail. But before we get there, let's start with the basics. All right, moment of truth. Can I work these slides? Yes. Okay. So what is the doctrine of public policy? So it's an ancient thing. Some authors point out it was simply the law for a long time before common law courts began to establish a log of legal precedent. And the earliest reported decisions are usually attributed to the 1400s onward, cases that involve the voiding of contracts for restraint of trade or clauses in a will that sought to constrain a beneficiary's ability to marry. It wasn't until the 19th century that jurists began to refer to a doctrine of public policy and defined its purpose as, quote, ensuring the common good of the community, its power as to render void that which is against the public good. So, talking about how this thing is informed, public policy is supposed to reflect the common values of a society. But that's a very vague term. What does that mean? Well, older applications of the doctrine were informed by things like Roman law or the teaching of the Christian church. But the modern approach, and by what I mean modern, I mean beginning around the 20th century, and the right one, I think, is applying the doctrine in pari materia. That is, in a way that complements existing statutory and other laws, to fill gaps when necessary. So what is meant by gaps are unlegislated areas of the law. So no specific law exists to ban a particular practice, but also there's no statute that's been passed that expressly allows it either. As we will see, public policy decisions concerning discrimination in the private law have been informed by things like Canada's Constitution, its democratic system of government, federal and provincial statutes, principles of the common law, previously established heads of public policy, Canada's Charter of Rights and Freedoms, its human rights legislation, and Quebec's Charter of Rights and Freedoms. Here it is, the unruly horse quote for all you folks keeping score at home. The fact that public policy is used to curb individual rights for the greater good, along with its highly discretionary nature, has made its use by judges controversial. Who decides what is, quote unquote, against the public good? Particularly when the impugn clause at issue is contained within a private instrument, only applicable to a handful of people, like a will. Due to this concern for a period in the 18th and 19th centuries, there was an effort by courts in the UK and particularly Ontario to confine the doctrine, to keep it to its established heads. Examples of these would be illegality, restraint against trade, restraint against marriage. However, all attempts to contain it, and indeed attempts to extinguish its use altogether, have ultimately failed. And the doctrine is best encapsulated by Justice McCarty of the English Court of Appeal in an early 20th century decision. He said, the truth of the matter seems to be that public policy is a variable thing. It must fluctuate with the circumstances of the time. The principles of public policy remain the same, though the application of them may be varied in novel ways. The ground does not vary. And that is, whatever is injurious to the interests of the public is void on the grounds of public policy. Certainly, we can see this with respect to the application concerning discrimination, which if you subscribe to the idea that public policy actually does have specified heads, I argue that this is probably the newest one to develop. The first application of public policy to curb discrimination in the common law is usually accredited to the 1945 decision of Re Drum and Wren. In it, Justice McKay, that's his photo there, voided conditions attached to a restrictive covenant in Toronto that forbade the sale of land to, quote, anyone of the Jewish faith or other persons of objectionable nationality. Interestingly, Justice McKay had other options open to him. He didn't need to use public policy. He could have found that it was an invalid restraint on alienation. It was uncertain. Perhaps it contravened Ontario's Racial Discrimination Act. And while he found the covenant invalid on the first three grounds, the bulk of his reasons focused on public policy. In his decision, Justice McKay explained how harmful discrimination in the area of property law based on race, religion, and ethnicity was, and how it was contrary to the basic notion of national unity in Ontario and Canada. He believed that, quote, nothing could be more calculated to create or deepen divisions between existing religious and ethnic groups in Ontario or Canada. And of course, this decision, as you can see, was released in 1945. And his reasons allude to the similar and costly lesson learned from the horrors of Nazi Germany, where such discrimination had been allowed to fester and grow within all facets of the law. In so finding, Justice McKay drew upon a number of sources. He looked to whatever Dominion and provincial acts were in effect in 1945 that prohibited the type of discrimination at issue. These included the San Francisco Charter, which we now recognize as the UN Charter, to which Canada was a signatory, the Atlantic Charter, to which Canada had subscribed, Ontario's Racial Discrimination Act, the Community Halls Act. Even he found an anti-discriminatory provision that he located in Ontario's Insurance Act. He also quoted Oliver Wendell Holmes, Cardozo, English case law, and what he was doing there was the practice of applying public policy in pari materia to fill a gap in the common law. There was no law at the time that permitted racially based or anti-religion-based restrictive covenants, but there was no law that prevented them. In this way, his judgment sought to fill that gap. Now, certainly there's a lot more to say about this case, including the fact that Bor Alaskan, who was then a professor at U of T, provided a very helpful and lengthy factum in this case that McKay is said to have borrowed on and relied on heavily for his reasons. But the case was not it was unopposed and it wasn't appealed. And notably, the next year, a similar case involving a racist restrictive covenant was heard with the opposite finding, that it did not offend public policy. And the Ontario Court of Appeal rejected Justice McKay's public policy finding for various reasons. And while the Supreme Court of Canada reversed the Ontario Court of Appeal and found the covenant invalid, it did so on reasons that had nothing to do with public policy. Racist restrictive covenants became a thing of the past in Canada, with the passage of provincial and territorial legislation beginning around the 1950s. But the ratio of Wren would be resurrected and applied to charitable trusts by the Ontario Court of Appeal, who would reverse itself on Wren's initial decision, but it would take 40 years. Canada Trust Co. versus Ontario Human Rights Commission. Many believe this case to be the authority on public policy and discrimination in the private law in Canada, but the decision itself contains a split on at least two key issues, and the split is unresolved by the Supreme Court of Canada because this case also was not appealed. Many of you will be familiar with this case. It involved the Leonard Foundation scholarships. They were established by way of a charitable trust. They had been administered by universities across Canada for decades, but by the late 80s, most institutions had disassociated themselves with it because the recitals of the trust, along with the conditions for eligibility, could only be described in modern day terms as white supremacist in nature. While both the Human Rights Tribunal and the Ontario Superior Court potentially had jurisdiction over the matter, the Ontario Court of Appeal decided it should assume jurisdiction because of its inherent jurisdiction power of CPRE, which is one of the two charitable trust amending powers that courts in Canada have as part of their inherent jurisdiction. For those of you joining us who are not in Canada and have little clue what I'm talking about, please message me afterwards and I'll try to explain it. But human rights tribunals don't have this power. So they assume this power, and they found unanimously that the conditions of the scholarship that restricted eligibility to white Protestant men and the recitals that declared the fate of humanity rested on the white race should be void for reasons of public policy. Notable here, again, is the effort of Justice Tarnopolsky. That's his photo there. He was a giant in the area of human rights law. In his minority concurring opinion, to engage in a painstaking application of the doctrine in pari materia with existing laws and values of contemporary Ontario. Just some examples where he drew from declarations by the then Premier of Ontario concerning the government's aim to combat all forms of racism. Wilson Jay's remarks in Baduria about how the preamble to Ontario's Human Rights Code was the public policy of Ontario. A similar observation made by the Supreme Court in a case called the Ontario Human Rights Commission versus the Borough of Etobicoke. Additional non-human rights oriented statutes that reinforce the message that the kind of discrimination at bar was contrary to public policy. And finally, Justice Tarnopolsky affirmed and adopted Justice McKay's judgment in Wren. He applied it to the area of trust law, reversing his own court on the issue 40 years after the fact. Justice Tarnopolsky quoted Justice McKay's decision verbatim, writing that he could, quote, think of no better way to convey the point that the promotion of racial harmony, tolerance, and equality is clearly and unquestionably part of the public policy of modern-day Ontario. So I mentioned, though, that there were two splits in this case. Here's the first one. The court unanimously agreed that the conditions offended public policy, but they were in disagreement over whether or not the public policy of discrimination, as Justice Tarnopolsky calls it in this case, could apply to private wills and trusts. The majority is pretty much not helpful. They're pretty silent on this issue. But Justice Tarnopolsky is very clear in his decision, and he believed it could not. And I've reproduced part of the quote at the bottom of the slide there. He was of the opinion that the public policy of discrimination could apply only to private law things that were quasi-public in nature, like a scholarship, privately established but available to a large body of candidates. The second split involved how to apply the doctrine in instances of perceived discrimination. The majority's reasons, they imply something like a smell test. It's difficult to describe it in any other way. That is, the discrimination at issue has to clearly offend public policy as to be incompatible with the functioning of a multicultural democratic society, such as the promotion of white supremacism. So this is really, it set the bar, and you'll see in subsequent decisions courts saying something does void or does not void public policy, and they will refer back to the facts of this case. So the bar was set pretty high. Justice Tarnopolsky, however, proposed an approach similar to that used in public law. So, for example, the test that you apply when a court conducts a Section 15.2 analysis, or the bona fide reason test under human rights legislation. But he said that it would have to be modified for purposes of private law because different considerations would be given different weight. But he advocated for this approach because he was concerned that all scholarships, including those that did discriminate on the grounds of race or sex or religion, but did so for the purpose of promoting underrepresented communities in certain academic fields, would also be captured by this public policy. So Again, this case wasn't appealed. These splits were not resolved. So, but what has happened since and honestly before this case was decided? Because one of the things that shocks English-speaking academics in Canada is, my God, Quebec's been up to this decades and decades longer than we have so many more cases on it than we do. But I'll get to that in a minute. So first of all, the doctrine of public policy has indeed been applied to private wills and charitable trusts alike. And it was applied before this case, and it continued to be applied after this case. So that portion of Canada Trust Co. has not been followed. As for the method of application, again, it seems the smell test has prevailed. Courts look for extreme examples of discrimination. In the case of charitable trusts, they have asked whether it was the actual intention of the testator to discriminate in a manner on par with the facts of Canada Trust Co. The better smell taste cases are those that are done with a litany of sources attached to them, again, done in the pari materia fashion. And I'll talk about some of those and give some examples. What I would say about these cases is that I believe they do represent a precedent for managing discrimination in the private law. But the discrimination has to be obvious, it has to be of a certain degree, and there are also clear limits to the doctrine's use in this manner. So I'm going to talk about all of that now, but first, we got to talk about Quebec. Sam was at this conference that we had this fall, but I used to write about this topic and I would skip over Quebec because I was terrified of the fact that it was a civil law jurisdiction and that it had its own charter. And that was very dumb of me. And luckily I stopped doing that and bit the bullet and started to study Quebec because I learned so much. So some people are dismissive of the jurisprudence that comes out of Quebec because it's, first of all, a civil law jurisdiction and things are codified. But the fact of the matter is, when it comes to public policy, the doctrine of public policy, there is a codified version of it called public order in Quebec. But as early as 1902, the Supreme Court of Canada said that both of these powers derive from the same broad discretionary decision-making power of judges. They are very similar. If you read the Quebec cases, they often cite the English case law, or they cite other Canadian case law, as well as a litany of other sources that inform their public policy. So there's no reason why we can't look at the Quebec cases too, and in particular wills cases that are that involve applications of public order. Those who do know about Quebec law might argue, well, wait a minute, when you're talking about discrimination in wills, they're not comparable because there's a specific section of the Quebec Charter that applies directly to wills. Section 13 of the Charter. So this is unlike the rest of Canada, right? Where neither our charter nor our human rights legislation applies directly to wills. Not so in Quebec. Section 13 of their charter says nobody may, in a juridical act, discriminate against someone. And Article 704 of the Civil Code makes it clear that a will is in fact a juridical act. So you shouldn't give up though when you see these things. You should actually read the cases and see if that's the truth, because it's not. When we look at the Quebec cases, first of all, the most important and interesting ones are pre-charter. So this doesn't matter at all. They were doing this long before they had a Charter of Rights and Freedoms. And if you look at the cases that follow the Charter, it's very difficult to find a direct application of Section 13. Really, it's still public policy that is doing the work in this area. And at best, it is informed by multiple sections of their charter. But that's no different from our doctrine of public policy. It also is informed by sections of our charter. So really, there are differences, they are subtle, but the two jurisdictions are comparable. And on that note, let's talk about the cases. So here are most of the cases. I'm not going to talk about all of them, but I will talk about some. This is your little basket of precedent if you're interested in this area of the law. First, I want to talk about some of the cases that I think are more helpful. And when I say helpful, I mean properly applied in a way that makes sense. Let's start with Quebec. Okay, so again, I said Rennes was the first common law application. Look at the date on this, 1888. Okay, this is nearly 60 years before Rennes. Justice Mathieu of the Quebec Superior Court voided a condition in a will that required beneficiaries to adhere to a particular faith or lose their inheritance. Now, some of you who are familiar with Quebec might think, oh, it's just because it was the Protestant faith and everybody was Catholic back then. But that's not the case at all. This case is fantastic. And as torts people, I think you'd find it very interesting because it actually involved the scenario of a train going by a house and the sparks from the railroad lighting the house on fire. So the homeowners sue the rail company for compensation. And what is the rail company's defense? That the people who own the house are not entitled to compensation because they only own the house by way of this legacy. And everybody knows that they're Catholics. All right, so this is what this case was about. It's a fantastic case. It's only available on a PDF in French on the dark web, but I found it and I translated it. And if you want a copy of it, email me because it is beautifully written. It is the most in pari materia application of public policy I have come across. The first footnote alone spans pages and pages and pages. It reviews French doctrine, but it reviews the laws of France, the immediate post-revolutionary laws of France, the current ones, the laws of Canada, specifically Chapter 74 of the Consolidated Statutes of Canada, English case law. It's so beautifully thought out. Pros and cons. It's as if the judge is having a philosophical debate with himself. And there's quotes in it such as, he's like, this legacy could engage the legatee to embrace a religion or to remain attached to a cult, contrary to his convictions. Let us leave these means of converting to tyrants who, like Louis XIV, did not shrink from the dragonnades. It's a fabulous, fabulous decision. So if you want an English version of it, let me know. Okay, so that's an example of a great in pari materia application of public policy to combat discrimination perpetuated by a will. Klein versus Klein, here's another pre-charter Quebec case. In this, you can see there was a stipulation that any of the grandchildren married outside of their grandmother's religion, they would be disinherited. Why this is a great decision is, again, take a look at it. The court exhaustively reviews all of the Canadian, the English, even the American jurisprudence on this issue at the time in the 1960s. And it rejects them all for the broader idea that such clauses violate a beneficiary's freedom of religion and are contrary to the public policy of Quebec. This case was decided during the Cultural Revolution of Quebec, when there was a huge movement to separate the state and the church. And so it's a really interesting time for it to be decided. But if you read it, it's an incredibly well-informed, transparent, and thorough decision that does review the sources, rejects the Supreme Court of Canada's decision, and says, no, we think that's not public policy. This is the public policy of Quebec. These are the reasons why, and this is where we're going. So it ultimately reflects an evolution of the law to a certain respect. It does cite Kimpton, that 1888 case. That's the only reason why I know that case existed, but it was also a pioneer decision. Next up, New Brunswick, McCorkle versus McCorkle. So this is a pretty famous case in this area of the law. A testator gifted the residue of his estate, worth about $250,000, to the National Alliance, a white supremacist organization based in Virginia. Mr. McCorkle's sister challenged the validity of the will on the basis that it was illegal and or contrary to public policy. Now, the gift wasn't necessarily illegal, and there's no time to go into the criminal law part of this, but Justice Grant voted the gift on grounds of public policy. And he did it because as he said, the purposes of the National Alliance and the activities and communications which it undertakes to promote its purposes would be illegal in Canada, and in any event, were contrary to the public policy of both Canada and New Brunswick. In doing this, he cited all of the references made by Justice Tarnopolsky in Canada Tresco, and he added that this application of the doctrine was also informed by Canada's hate speech laws that are contained in our criminal code. But notably, this was an expansion of the doctrine, right? Never before had a gift without conditions been voided for reasons of public policy, right? In the past, it had been conditions of a will or a trust that had been voided, that were the subject of the doctrine's censure. And some have expressed unease with the scope of this decision because of that. But I think perhaps a mollifying factor is that the government of New Brunswick, the sole party that was in a position to actually legislate on this, was instead an intervener in this case, specifically requesting that the court void the gift on the grounds of public policy. And finally, I would want to talk about at least one of the trust cases. This is always my favorite, Royal Trust versus Canada. This is an important charitable trust case because I think it establishes two things. First, it confirms that the pattern of courts when they look at charitable trusts, so basically scholarships, is that the actual intention of the testator, like what did they intend to do? Did they intend to discriminate and in a really bad manner? Matters. And secondly, it also demonstrates that lawyers in this area are becoming aware of how the law is evolving in Canada. Okay, so in this case, it's a fairly recent one. I don't know, I think I forgot to put the date up there, but so 2016, I think, 2017. A testator sought to establish a couple of scholarships at Western. You can see what this is word for word what the conditions were, right? So the first one was for Caucasian, and then for some reason, in brackets, white, just to be clear, male, single, heterosexual students in scientific studies, including medicine. The one for women was to go to a hardworking, single, Caucasian, white girl who is not a feminist or a lesbian. Special consideration if she's an immigrant, though not necessarily a recent one, but not for medicine. And then curiously, no awards to be given to anybody who plays intercollegiate sports. So people who played sports were out. Anyway, they went to court. And I think Western took this to court, perhaps hoping for a similar outcome that happened in Canada Tresco. Can we void the conditions? Can we keep the scholarship? And so the first thing about this is the decision tells you what the approach of courts has been with respect to charitable trusts. The judge says, although it's not expressly stated by the testator that he subscribed to white supremacist, homophobic, and misogynistic views, the stated qualifications in these paragraphs that I've reproduced leave no doubt as to the testator's views and his intention to discriminate on these grounds. The plot twist, though, is that in this case, the settler included a kill clause, a clause that instructed that in the event of the scholarship's qualifications, quote, adjudged by a court of competent jurisdiction to be void for public policy, that the gift would be withdrawn entirely. To me, that signals a general knowledge and acceptance by those practitioners in the field of wills and estates that the discrimination attempted in Royal Trust is incompatible. It won't fly with current day Canadian public policy, and it wouldn't survive a public policy application. There are some less helpful decisions in this area. I'm not going to go into them in detail, but they're not helpful because either there wasn't enough citations given or any citations, or perhaps the key phrases that are helpful could be judged as obiter, or they're just very confusingly and sloppily applied. But they can't all be winners. Okay, now let's talk about some other cases, some very important ones. And one of them is Spence versus BMO Trust. Again, this is around 2016, the same year as McCorkle. It was very interesting. You had these two big cases on the same issue in two provinces, two courts of appeal. Both of them were appealed. The Supreme Court waited until they were both decided and then refused leave on both of them together. So such a wonderful and typical scenario when it comes to poor old wills and trust law. Okay, so what was Spence about? My views on this case are mixed. I think for the most part, it was a good decision, but I also think it goes unnecessarily far. It wades in because it wades into a hypothetical, which courts should never really do, and just contains some unnecessary confusing messaging. Okay, so Spence was released the same year as McCorkle, and the clause at issue in this case, though, was quite innocuous. All it said was, to my daughter, I'd leave nothing as she has shown no interest in me as a father. However, third-party affidavits were introduced to prove that the father had cut his daughter out of the will because she'd had a child with a man of a different race. At first instance, remarkably, the entire will was voided for being contrary to public policy based on the motivations of the testator. But for several reasons, the decision was overturned by the Ontario Court of Appeal, and I agree with the first two. Not to get too technical, the first was based on the rules of evidence in a state law. And really, in a nutshell, in Ontario, affidavits like that should never have been admitted into evidence based on the circumstances before the court. And two, the will itself is completely innocuous. It doesn't instruct the beneficiary to do anything. It doesn't impose any conditions. It doesn't say anything that would offend public policy. So, and I do believe that we should not be looking too far beyond the face of the will when it comes to public policy. And I think that should actually be applied to constraints on marriage as well. But that's a different presentation. Okay, the part of Justice Cronk's decision that I don't love is when she wades into a hypothetical and she asks, as I have said, Eric's will does not facially offend public policy. But what if it did? Was it open to Eric to disinherit his daughter in his will on discriminatory grounds? That is, on the express basis that the father of her son was a white man, without triggering reviews by the courts on the grounds of public policy. And Justice Cronk's response to her own question was that such clauses, no matter how discriminatory in nature, should never be subject to public policy. The main problem I have with this is just that it was unnecessary. It sends a really unsavory messaging. And, you know, this is less of a concern in Ontario because adult children are almost never guaranteed a share of their parents' estate, even through dependence relief claims. But places like British Columbia, they are, unless a testator has expressly provided sound reasoning in his will as to why he left his children what he left his children. Okay, less than expected, nothing at all. What happens if Spence is followed in BC and the reason in the will is, I have left this child nothing because they are gay and they are a shame on their family or something like that? I'm not saying that the variation of wills, which falls under its broader act in British Columbia, is governed solely by public policy, but there's something there that makes me very uneasy about saying that public policy, which has been so far the main tool used to censure or at least manage discrimination in wills, there are passages in wills that are immune to public policy and to its judgment. But apart from this point, I think the rest of the decision is correct. If there's nothing on the face of a will that offends public policy, then a court should not delve deeper into a testator's motivations because this can get wildly out of control. And again, I'm all for this. I think we should apply this to a whole other area of wills, which we don't have time to talk about today. So now that we know what Spence stands for, and Spence, was denied leave by the Supreme Court of Canada, so it's not the law all over Canada, but it's quite persuasive. It's been cited in at least 5 different jurisdictions, other than Ontario. Let's look at the last case I want to talk about today. The Kenneth Hilborn Scholarship case. That's not what it's called. It's probably called Re Kenneth Hilborn Estate. Kenneth Hilborn was a professor in the Department of History at the University of Western Ontario. He died in 2013. And he bequeathed a gift to Western of $1 million, most of which was directed to the Department of History to establish scholarships for undergraduate and graduate students. There weren't very many conditions attached to these scholarships, and none of them were offensive. The main condition was that they bear his name. They'd be called the Kenneth W. Hilborn Scholarships. The university accepted the gift, settled the trust, and started posting about it in 2016. The scholarships began to be awarded on an annual basis, and then shortly thereafter, the trouble began. In 2019, 2 scholars published online articles detailing Hilborn's views. And it turned out he wasn't the friendliest of fellows. So in his early years, apparently he was a staunch defender of apartheid in South Africa, warning against the specter, quote, of Black domination, quote, posed by, quote, one man, one vote democracy. He wrote pamphlets for organizations such as Canadians for Foreign Aid Reform and the Northern Foundation, both of which had white supremacist ties and goals. In the span of his over 4 years at teaching at Western, while he failed to produce a single peer-reviewed article, he did produce a great number of literature that focused on the exposing the evils of multiculturalism, feminism, student activism, LGBTQ rights, and in his final years of tenure, he transitioned to perpetuating Islamophobia, and as well as his dismissal of the term racist as a, quote, term of leftist term of abuse. Okay, so I don't know what was going on, but that's apparently the reputation that he had. Those were his writings. So a scandal started to brew, and in August of 2020, a committee was struck called the Hilborn Working Group. And its purpose was to look at these online articles that have been written about Kenneth Hilborn and see if they had any merit. So this committee met, and drawing a distinction between opinions they didn't like and publications of his they believe caused harm, concluded that Hilborn participated in epistemic violence by suppressing, dismissing, and trivializing people who were oppressed, vulnerable, or discriminated against. The group believes that Hilborn's academic work bolstered white supremacist arguments, attached importance to the safety of white people, never Black people, and affirmed the goodness and superiority of white people explicitly. The committee recommended to Western that it either revisit its decision to accept the gift, or, if the university decided to retain the request, that Hilborn's name be removed from the scholarship. Both were a problem for the university. For those of you unfamiliar with the area of charitable trusts, which might be everybody except Adam, I don't know, the trust had already been settled. So any modification to it required the Ontario Superior Court to exercise its powers of inherent jurisdiction. The university chose the second option, attempting to remove his name from the scholarships. So Western sought the following relief in its pleadings. 1, a declaration and order that the applicant, as a trustee of the scholarships, is entitled to rename and redescribe the scholarships to delete Hilborn's name, and then such further relief is required. And it did so by asking the court to use its scheme-making power. So recall in Canada Trust Co, I said that they use the doctrine of cypre. There's 2 inherent jurisdiction powers of a court to fiddle around with charitable trusts, and only charitable trusts. And the scheme-making power is sort of like the little brother of cypre. So the doctrine of cypre is employed when it's impractical or impossible to continue applying a trust in the manner that the settlor wants. The scheme-making power is best described as perhaps it goes to the mechanics of how the property devoted to charity is to be distributed. So about the sort of mechanical inner workings of a trust, if you look at the cases that have been reported in Canada on this, Um, they sort of revolve around that. And I'll give you an example in a second. But the argument that was used by Western to support its request that the court use its scheme-making power to remove Hilborn's name was that including his name in the scholarships was, quote, inadequate for contemporary needs. Inadequate for contemporary needs. Remember that phrase. Because maintaining the scholarship in Hilborn's name, the university would be tacitly condoning and endorsing his views, views which would conflict with the university's goals and values of equity, diversity, and inclusion. Now, the term inadequate for contemporary needs is a phrase associated with the scheme-making power. It comes from another case called Killam Estate. But that case was quite literally about changing the machinery of a trust. In that case, the issue was whether the court would allow encroachment upon trust capital to supplement trust income, rather than have it operate on an income-only expenditure model as per the instructions of the late trustee. So they sort of saw that phrase as contemporary needs and ran with it. But if you look at the case that it's based on, it has absolutely nothing. There is no correlation. There's no link. In my opinion, this was clearly a public policy application disguised as a trust case. And there's a reason why it had to be, right? So unlike Canada Trust Co. with the Leonard Foundation scholarships, there were no offensive terms to these scholarships that rendered them impractical or impossible to operate. You know, had everybody been refusing the scholarships because they knew who Kenneth Hilborn was and no one would accept it, maybe then the doctrine of CPRE could be employed, but that was certainly not the case. They had administered them, people were accepting them. Instead, really what this case resembles are the facts of Spence, right? There's a document that's neutral upon its face, and you need to look behind it to understand the bigger picture. So had they tried this as a public policy application, they would have failed. That's my guess. So instead, they applied as a trust application, and after a couple of bumps, I mean, the first application was unsuccessful. The judge held that the materials submitted were insufficient to grant the relief sought, but she didn't seize herself of the matter, and they reapplied, and the second judge gave them their order. Let's take a look at that judgment. So here's the judgment. You'll note it contains no written reasons, no law, no precedent. All it says is, on reading the application record of the applicant and it's the applicant's file and the affidavit of Paul Ulichuk, they declare that they're going to exercise their scheme-making power and permit the varying of the names, descriptions, and allocations of the trust, known as the Kenneth W. H. Hilborn Scholarships. That's the rest of the order. It's a page long. And it says, notice here, I can't really read it properly because there's a whole bunch of other things on my screen. However, the applicant is entitled to vary the names and descriptions in accordance with Schedule A. Well, let's take a look at what Schedule A says. Oops. I don't know if you guys can see this clearly or not. First of all, they've removed his name from some of the scholarships, but they've changed the descriptions of them. And they are actually giving, so preference will be given to students whose internship engages with a history of race and racism or other forms of discrimination and will enhance the understanding of equity, diversity, inclusivity, and public history. Preference is also extended to students in unpaid international internships. I mean, you know, Kenneth, based on what we know of him, and I'm not gonna I don't know for sure, but I think like if he saw this, he would be rolling in his grave. The idea that is though this application was unopposed. No one opposed it. No one came forward to represent his estate, to argue that, you know, he left you a gift. He didn't put any conditions on the scholarships except for that they should bear his name. And now you've basically asked the court to rejig the scholarships, including their eligibility. You've added conditions yourself to them, which is a complete violation of the agreement and the trust that was settled. Um, so what do I think about this? I thought I had a nice concluding thought slide. Maybe I can go like this. Sorry, I'm not very good with the computers. That's the Arendelle star from The Lord of the Rings. I thought that was very clever. Um, I a friend and mentor, Bruce Ziff, once said, "The law can only do so much to make a world a better place. Nevertheless, it should do as much as feasible." And I guess the question is, what is feasible when it comes to public policy? And in particular, its application to discrimination in the private law. I think while the results of Hilborn may be deeply satisfying to some, I worry that it and decisions like it might compromise the strength of public policy's flame when it comes to discrimination in the private law. It's not a public policy case, but it kind of is. It is the spirit of public policy that drove that decision. It has nothing to do with the scheme-making powers of inherent jurisdiction. And I'm just worried about, now it's an unreported decision, but I'm worried that in certain person's hands, it's great fuel for the fire in terms of diminishing the legitimacy of the public policy doctrine. But I do think that I've shown you some cases, and I hope I've opened up the discussion, that if public policy is applied in a transparent and coherent way in pari materia with the rest of our laws and the values that are reflected in those laws, it can be a legitimate tool to be used in circumstances of somebody attempting to use areas of the law that are not subject to the usual anti-discrimination checks to perpetuate discrimination. I guess like I just would like to say, this is just one small area of my research. Marriage constraints and wills is something that I'm working on right now that I'm very interested in. And I guess you'll just have to schedule for me for another presentation. That's it.
Up on that. Thank you so much, Jane, for that really instructive walkthrough through the case law, and in particular, the great research you did on the Quebec civil law aspect of it too. I think that probably novel for many of us. So I'll open up the for Q&A, and I think you can just either raise your hand or put your name in the chat if you have a question, and I'll take the cue and try to moderate. I do have some questions of my own, but maybe we'll see if anybody else wants to go before I sort of jump in.
That was perfect. Great. No questions.
So maybe as everybody's formulating their thoughts, I think, Jane, so I think I had a question right about drum and rant, right at the sort of close to the beginning in the common law. And I think what strikes me about reading Justice McKay's reasons in that case is, yeah, like it's clearly writing in sort of the aftermath of World War II and noticing how discrimination and sort of social strife between, in that case, religion and race can like cause be the catalyst for really significant social unrest, like war in that case.
Mhm.
And so, like, what I think is useful about it, and is that, like, when we think about the unruly horse, one of the problems with public policy, one of the things that make people suspicious about it, right, is that judges will just say, "This is what I think public policy is all about, and these are my opinions." But what is great about Justice McKay's invocation of like civic peace is that how do you not get on board with that idea
Yes.
of the society post World War II? So it was kind of a neutral position, or it's like what political philosophers would say, but there can be an overlapping consensus that this is public policy, regardless of what kind of specific moral religious beliefs that you have about how we should pursue the common good. And I think that certain things that Justice Tarnopolsky does in the Leonard Foundation Trust case have that same quality, because he's not saying here's what I think is public policy. He's saying, like, look at these statutes that the Ontario legislature have enacted. He talks about international law
Mhm.
instruments, although that's maybe more fraught. He talks about the charter, the Canadian Charter of Rights and Freedoms, as a constitutional document, and says, regardless of what I think, right? This is clearly what this jurisdiction's people are committed to. And so it's kind of like a sociological inquiry, right? Like you can accept, their conclusions about what public policy requires in Ontario, regardless of whether, Justice Turner Pulaski himself accepted those beliefs. So I guess I wonder, like, do you think that like, does this sound like a plausible reading of these cases in your
Well, what you've just described is the method of reading them in pari materia. So you have to actually back it up. You have to create a pretty good argument if you're, especially if you're going to evolve public policy like those cases did and say, look out, we're not going to find this clause about the Jewish faith void because of those very questionable English decisions that base it on the doctrine of uncertainty, which were likely anti-Semitic in and of themselves, because it's just shocking how being a Catholic or being a distinct branch of Protestant or whatever was certain, but not Jewish. We're not going to do that. It's foolishness. We're going to do this based on the fact that it's discrimination and it's wrong. But we better back it up with a litany of sources, not just what's in our heart. And that's the best that you can do. Now, some people will say, well, you can pick and choose what you want in a pari materia. Well, maybe. I don't know. Have you ever engaged in the exercise? Because I have. I'm finishing up with a second gigantic paper on marriage clauses where I make the argument. And yeah, I found a couple going the other way, in terms of, supporting the methodology behind the current public policy on it. But 97% of all of our laws, our jurisprudence, our institutions, weigh against it. And that's how you do it. Nothing's going to be perfect. You look at the public law. Anybody who studies the public law studies Section 15. Pour one out for Section 15. It can go any which way, right? Because it's about the balancing of interests in the end. But it has to be, you have to have something you're balancing. You have to be transparent.
Yeah, no, I guess then my question was just basically answered it. Like, what's the methodology for like a that can be recommended to judges who are doing this? It's like they have to be able to distance themselves in a way and show. And there's something similar, I think, that goes on in the criminal law. Like what the Supreme Court says about obscenity is like it's not necessary. This is might be of interest because of the how some of the cases you mentioned draw on the crime of hate speech, for example. So if we look to the
Mhm.
criminal law, obscenity, the Supreme Court says in Think LaBey that it's not about, it's about what we can actually see as obscene because it's contrary to constitutional values, essentially, like what is codified in the Constitution. So again, trying to find these kinds of like a sociological rather than normative inquiry into what counts as public policy. So is the
Mhm.
best advice to judges just that they have to be the best sociologist that they can or best descriptive social theorist that they can?
Oh, I
Um,
don't know. I mean, it depends. And I think they're screwed any which way. They're gonna be skewered. These are very controversial decisions, right? They shouldn't be frequent, but when they're necessary, they should happen. And I always say, in McCorkle, if because people say this is too far, it doesn't matter for the legislature. I'm like, the legislature was a party specifically requesting that the court void this through the public policy doctrine. So I think it's a necessary tool that'll always be around. We just have to be careful with it. That's the best that I can really do.
okay, I have many more questions, but I'll defer to Adam, who has his hand up.
Thanks. Thanks, Jane. That's interesting. I have a lot to say about this topic, but I mean the typology in my mind that I think through with the kinds of cases that you've referenced is you've got discriminatory conditions in wills, right? You can't be in a gay marriage. That would be a restrictive condition attaching to a beneficial interest. You've got discriminatory exclusions. That's Spence. That's a non-disposition. And I think the non-disposition is the easiest one to deal with. If you're not compelled to share, there can't be a wrong reason for not sharing. You're not compelled to share. At that point, the reason for not sharing is irrelevant legally and theoretically. If you're not entitled to share in someone's estate, there can't be a void reason to not share. And by the way, what's the remedy for not sharing? Forced sharing? Like that case is, I think, intuitively right in its outcome, even if what it does mean is you can have a bigoted reason for not sharing. But that might be one of those cases where the remedy is actually worse than the problem because the only remedy is forced sharing. And
That's what we
we
have.
have no benchmark for determining who shares in what proportion.
Well, we have
Like,
that in five of the 10 provinces. We have forced sharing for adult children.
yeah, but legislatively. So legislatively, the rule is you can't arbitrarily exclude people. So there's a baseline entitlement established in law. So that one seems to be an easy one. And then McCorkill is an unconditional disposition, but to a bad actor. And what the court basically says is we want to cut off the flow of property to bad actors. And that reasoning as a precedent terrifies me because it's a court using public policy to decide who gets to enjoy the rights of property in the first place, right? And so if bad actors are that bad, why do we let them have bank accounts? Why do we let them lease cars? Why do we let them hold property of any nature if they're predisposed to use property rights in invidious ways? I mean, that reasoning goes nowhere good. And so those are sort of some general thoughts. But the one thing for me, when I think through this topic, and you alluded to it, but to me, it actually really is the most difficult question here. And it's this: why do human rights codes set limits on their boundaries? So succession is not covered by the Ontario Human Rights Code. Why not? Like somebody who drafted that statute decided that we're going to enforce on a vigorous anti-discrimination norm in certain facets of social and economic life. And they excluded from that inheritance and wealth succession and benefaction. What you see with the public policy cases is the court saying we're just going to universalize anti-discrimination norms, regardless of the boundaries that human rights codes set, regardless of the fact that constitutions don't govern private actors, they govern state actors. And we're just going to universalize those norms under the rubric of public policy. I think that's a deeply, deeply problematic model of judicial reasoning. And so that's a way of sort of priming this question. Why does the Human Rights Code set boundaries? And why would we think that courts can just disregard those boundaries and universalize the norms that evolve out of human rights codes under the doctrine of public policy? It's transparent judicial lawmaking and in a pretty gross way in my view. Anyway, that's a bit of a provocation. So I'm curious
I would
for your
expect
thoughts
nothing
or the
less
group's
from you,
thoughts.
Adam. Oh, it's so great to see Adam here. I like to refer to him as my arch nemesis, although that's not true. We just disagree on this fundamentally. Okay, I want to respond to a few things you said. I had to laugh when you said, forced sharing. In other words, adult children's right to challenge their parents' wills is legislatively controlled. That's really hilarious because it's even more discretionary than a public policy ruling. Yes, it's codified under the dependence relief statutes or the various passages of wills variation, but it's basically a one line that said the testator did not provide adequately. And it's completely open. In fact, charter values are what guide it usually in public policy. So it is, I think if you had to find the most discretionary legislative provision in Canada, it would be that line in all dependence relief statutes. So I do think that if Spence made its way over to BC, which I don't think it will, because the wills communities in those jurisdictions are diametrically opposed. They couldn't be further apart on a number of grounds. But what are we saying that, discriminating passages in wills that exclude children on really offensive discriminatory grounds are immune from review by public policy? I don't know. It makes me uncomfortable, but we don't have to agree on that. McCorkle, I
Well,
guess,
can I just
no,
intervene?
no, you can't. You let me
I
finish
can't.
first.
I can't.
No. Okay, so the second, although I appreciate your spirit, the second thing is McCorkle. Yeah, if you look at it the way that you just described it, it does seem terrifying, but it's not really. Okay, we don't let the KKK or organizations that would be illegal in Canada. We don't allow them all of those rights that you just talked about. The judge found the National Alliance would not be legal in Canada. It would violate the hate speech laws. It's that it was in Virginia where they don't have these laws, and it was a gift to that organization that created that sort of perfect storm. I'm not discounting what you said, but it's much more extreme than just that they were a bad actor. They had a radio station dedicated to denying the Holocaust. Their founding papers were to quote unquote start a race war. So, you know, I mean, again, your point is taken, but it was quite an extraordinary and extreme example.
But racists can't hold property in Canada?
As they weren't racist, they would have violated our hate speech laws. There's a big difference.
No, but even still,
No, no,
they can't hold property.
No, Adam, you can no. Shh. I didn't interrupt you. You can't interrupt me. Okay. So the last thing I want to talk about, the last response is what was the last thing you were talking about? The big thing about.
Well, no, it's about the boundaries, so that the
Act.
Human Rights Code set
Right,
boundaries.
yeah. Okay, great. So the human rights codes, you're right. Human rights codes leave wills out of it. And so your point is that the courts are creating their own laws in the face of the human rights codes expressly leaving wills out. Well, my response is there's no express law that permits people to wildly discriminate in wills. And why hasn't there been? If the governments are so upset that the courts are doing this because they've been doing it since 1888, why not have the political courage to write in your will statutes? And by the way, this is immune from the doctrine of public policy because they can do it and that would end it, but they don't. And we have to ask ourselves why they don't. We have to ask why the government of New Brunswick was an actual intervening party in McCorkle in requesting this relief. And I think you know what the answer is. So it's not, you can't just say the statute is silent on this. I mean, that's what people talked about in Christie versus York, where they denied a black man a drink at a tavern in Montreal. And Bor Alaskan, who was a kid back then and wrote the only paper that criticized the decision, said, what is this crap? Just because the statute is silent on it doesn't mean they allow it. That can't be right. That's my response.
Okay, so maybe Adam, one quick reply because we have three, we have three others on the list that we want to get to before 1:30. But I want to give you a chance to quickly reply.
You know what? My reply won't be quick. I think the issue for us to think through there, and I'll leave it at this because it really is a part 2, 3, 4, and 5, hopefully, with future discussions of this. I think that the nature of the interests engaged and access to the marketplace and access to the employment are fundamentally distinct from access to benefaction. And I actually think that's the reason why the legislature, in its wisdom, chose not to intervene in every feature of social and economic life, that they drew those boundaries for principled reasons. And I think being denied benefaction for any reason might be a feature we'd be willing to live with for not unprincipled reasons. It's not the same as employment. And Reed Drummond Wren's the same thing. You're taking a whole portion of land and saying it can't be sold to Jews. That's what the wording of the restrictive covenant said. That's very different than saying, I'm not leaving you a portion of my estate through benefaction because you've converted to Judaism. I think that the interests engaged are different. And again, defending that is a little bit like defending freedom of expression. The only time you ever have to defend the freedom is when you've got an invidious bad actor that everyone wish, quite frankly, would just go away. But that's not a very good legal standard for intervention. But anyway, it's too much to say, so please.
No, thank you both for that exchange. We'll have to leave the sir rebuttal for another day, I think. So
you should hear our phone calls.
Okay, good.
Just a little sample.
So I have Sam, Martha, and Catherine. So we've got about 20 minutes, which should be enough time, but maybe just be mindful to try to allow everybody to ask their question.
Thanks, Anthony. Thanks, Jane. Maybe I'll pick up on that exchange from a slightly different perspective, actually, to keep it going. So I was thinking about sort of the doctrine of public policy in this sort of wills and trust context, and how it fits alongside kind of other common law cases where the common law allows intervention with private autonomy for the public good, for public policy reasons. So I've been looking at that in the context of the defense of public necessity and tort, bringing tort in there. And there's an interesting sort of part of the discussion in the UK Supreme Court's case in Fern and Tate Gallery, which is about nuisance, and sort of the discussion refers to takings doctrines as well. And Lord Leggett sort of refers to how there's circumstances in which property rights can be subordinated for the public good or the general good of the community. But the public interest can't justify denying the victim any rights at all in those circumstances, and so, or any remedy rather at all in those circumstances. So in the tort context, we generally frame it in terms of there are just some cases in which you can't get an injunction to stop somebody from committing tortious actions against you, or from sort of intervening with your rights, but you might still have an award of damages as sort of a secondary remedy, even though you can't sort of stop the conduct in advance. So I guess I was thinking about your discussion in that kind of sort of that broader context, and whether there's kind of a secondary recourse for kind of the party that is on the bad side of the public, the parties being impacted by public policy. Now, of course, in the trust context or in the wills context, the person who's most going to be aggrieved by this is literally in their grave, and so yes, you don't see the opposition there. But I can imagine that one solution is, of course, striking the problematic terms from the instrument. Another is just unwinding it and restoring the original position. So I guess I was wondering about sort of whether you come across cases or ideas which might, through using secondary mechanisms, then place a kind of constraint on the potential unwieldiness of public policy that Adam's concerned with.
Well, I think those are interesting points. It's sort of like it really does depend on the scenario. So the Hilborn Scholarships case, why I find it so unsettling is because he was still alive when he settled that, when he made that trust, when he settled it with the university. It was almost like an agreement. It was a deal that they were doing, right? Like, it was very clear. I think that's very different than somebody who uses their will to try and control the intimate life of a beneficiary. So to my son, this is a real will, so long as he marries the surrogate mother of his child. Now the son is gay and married to another man. Okay, so but that was a will, and your son he'll receive some money if he does that. Now Adam might say, well, it's just a gift. He can walk away with it. It's not coercive. No one's holding a gun to his head. And then that's going to take at least an hour of me to talk about all different reasons why I don't agree with that, and I think that's wrong. But I guess I start with a very basic one, is that in this economy, it's very difficult for people to walk away from gifts. But it's also, I think that the bigger question is, and you sort of touched on it when you said these people are dead. It's not just that they're dead, but they're dead and they're not entitled to this level of control over the living. And they could get away with it. If nobody challenges this, I'm not advocating for rise up everybody and take these wills to the court and judges do this of your own motion. I'm advocating for the basic bare response of a court not debasing itself to a level where it's going to police somebody's sex life, where it's going to police some really distasteful, gross, discriminatory clause in will. I think that brings the administration of justice, if not into disrepute, it's pretty bad. It's pretty bad. Anyway, I could talk about this at length. I'll leave it there. I am hopefully going to be publishing something that sort of gets those arguments out, and I pray to God Adam's not my peer reviewer.
Thank you. Martha?
I'm just teasing.
Thank you so much. This is such a great project. Jane and I have talked about this because when I teach at the University of Maryland at the law school, and I also do private law and justice stuff, but from the contracts side of things. And I'm particularly interested in social contract theories that justify reparative remedies. So when I was in Canada, I spent some time reading Noble v. Wolfe and Drummond Wren, and was really interested in ways that the racially restrictive covenants both overlap in the United States and Canada and are quite different because of course, our case law is about anti-Black reasons for the covenants, and in Canada, it's more the Jewish piece.
We have both, sadly.
Yeah, depending on where you are, right?
Yeah.
But presumably the same idea would apply in both circumstances. So what I'm interested in, and I love the fact that there's this workshop on tort and justice. I just think this is great. And so my question is a cross-border question about the relationship between public policy and equity. So I'm pursuing a restitutionary argument based on unjust enrichment to say the developer that did the beach property in Noble v. Wolf now has, perpetual life, and so they still are making money, or maybe the family gave a lot of money to a foundation. Now the foundation is doing it. Can we hold them accountable for that unjust enrichment? More like a sword, really, than the shield. The public policy presumably would be a shield, and restitution is based in equity. So I think of public policy as based in equity too, but in like equity as opposed to common law. And I wonder if in the Canadian context, equity has a piece of this because it comes with the spiritual history, which you referenced.
I'm not sure if I'm understanding all of your question, Martha. In terms of the sources of public policy, it is based in equity, in my understanding of equity. I mean, some of the earliest cases were applications of the courts of chancery, which were courts of equity, applying the doctrine of public policy to wills. And so, but how that links with reparations, I don't know. It's not that your question is weird. It's that I have a huge blank space in my mind. I don't know very much about this. Maybe somebody else on here knows the answer.
Well, I'm interested in the equity piece because just about every piece of equitable relief has that mush of injustice can only be avoided. So it's the idea of the prime directive of laws to do justice, and we want certainty, but sometimes there has to be that mushiness that you mentioned that's behind all of this.
Well, I'd love to chat with you more about this, but I can't
We will.
answer it right now. It's a cool question, though.
I think before we go to Catherine, maybe it's helpful to maybe this is something in the Canadian context that's reflecting what you're thinking about, Martha, but it's not super clear, but the Supreme Court of Canada seems to think that like charter values when developing the common law of private law they seem to think they can't be used to like create new causes of action. But like if a rule if a rule were to undermine a charter value, then the common law can be changed so that it avoids doing that. But there's a separate question about whether that's the sort of shield. But can it be stored to like create a new cause of action? That's a torty way of putting it. But anyways, maybe that's one way of thinking about, which is I think a hard question. Seems to me to be a puzzle under Canadian law. So.
Okay, thank you. Thank you very much.
So Catherine, and we do have another 10 minutes, so we should be comfortably within our time.
Yeah, hi, thank you, Jane, for the presentation. I will be writing you for that 1888 case.
You don't need it, though.
Criticizing, sorry?
You don't need it. I'll just send you the original.
I can take the original. I want to see criticism of Louis XIV. It's very topical and relevant. I'm really curious. I have a much narrower question, which is, I think, kind of in line with Samuel's question. You mentioned kill clause having been in one of the charitable trust case, and I understood that it worked, right? So would that be the way that people ensure that from the grave? Like, do you see this becoming big enough that it will solve the issue for the people creating charitable trusts before judges have a chance to look into it? Or like, how would that sort of modify the unfolding of this area of the law if they did become as popular as they might be?
I had a long conversation with my husband about this because we were supposed to write a paper about this years ago. Never, ever get into a co-writing project with a law school dean. You will regret it until the day you die.
Noted.
My half paper has been done for years. And he has still not finished his half paper, but the paper is about this idea of when it comes to scholarships that discriminate, what applies? Public policy, the Human Rights Code, or maybe charter? And when do they apply? What happens if a scholarship, for example, he was desperately trying to think of a scenario where it was a private club, but they offer no services, right? They don't have a restaurant at the club. No one would want to be, it's like a bunch of people who meet at a house maybe, and they want to start a scholarship and it's really discriminatory. How does that even get into court and why does it offend public policy? It was a really interesting exercise. And we didn't really conclude because one of our kids woke up and started screaming. So we had to deal with that. But I will say, with respect to kill clauses, I found that case really interesting. And one of my students wrote a paper for me as to whether or not the court could have applied the doctrine of si pre regardless of the kill clause. And I can't remember what angle we had it at, but at any rate, I think it does work. But it also means that the person doesn't get to establish a scholarship at all. And I guess maybe they're told, this is not going to fly if you want it to go through a university. So you can't do that. That's fine. But that sort of reinforces my problem with the Hilborn case, is he kind of did comply with that, right? He didn't do what the testator did in Royal Trust. He set up scholarships with completely innocuous conditions, and it was still changed. And that's why I have a problem. I think there has to be some sort of limit there, and I think it was crossed over in that case. But like, there's lots of ways that we can be nasty to each other that the courts can't reach, right? There's lots of ways that parents can make their children do awful things or discriminate against other objects of their bounty. They don't have to do it through way of a will. And we can't reach all those places, but it's like Bruce said before, we should do as much as we can. And we should not make a mockery out of our judicial system, asking them to police some of these really capricious whims of the dead.
Yeah.
Sorry, go ahead, Catherine, if you had another point to add.
No, that was it. Thank you.
For what it's worth, on this point, there's a recent article in the Cambridge Law Journal arguing that anti-discrimination laws should extend to parenting decisions about how kids parents treat their kids, if they give more chores to their daughters as opposed to their sons or something like that. Now, I don't know if that's going to have any traction or anything like that, but there is some discussion about the broadening the reach of anti-discrimination law, and like if you can't discriminate in distributing household chores, then presumably you can't discriminate in like who you leave your money to between your kids, right?
The point is this, Anthony, I'm sorry to interrupt, but before I forget, I'm so glad you raised that, because the point is no one's gonna know if you're not in court. But why are you in court, right? So this is a whole other thing, but I'm a family law professor as well. And I was a family law lawyer before I became a professor. And, there's been a lot of parental rights talk, particularly in New Brunswick, and it always makes me laugh because there's absolutely no such thing. There are privileges, and they can all be taken away by a court when it comes to respect to your children. But if you're not in court, then you absolutely can't discriminate against your children. But once you are in court, and that's why it's sort of like wills, like once it gets before a court, are you going to ask a court to condone a certain type of behavior? That's sort of the issue. I think what you're talking about is different. Should it be subject to like a human rights code or some other law to sort of govern discrimination within the home? I get that. But I thought about this for a while as a sort of a parallel, and I actually started researching, are there family law decisions where discriminatory behavior by parents has been censured by a court in the context of a parenting order?
Right, or child protection, because there are, if it rises to a level of emotional harm, it seems like really flagrant discrimination could count as emotional harm, potentially. I don't know. That's also kind of speculative. But the other thing this was, I guess, the last question I held on to while going through the queue is something you just mentioned too. So it seemed like Western, when it came to Hilborn, they kind of said, we can't hang on to this scholarship and operationalize it because it'll somehow implicate us in it. And it'll be contrary to our values of equity, diversity, and inclusion to keep the name, for example. And so I just wanted to point out, it seems like there's a similar sort of reasoning in the U.S. Shelley versus Kramer case where the issue is like courts don't want to see themselves as complicit. And there's arguments about how to understand unconscionability in contracts too, by saying that like what it is that courts don't want to get their hands dirty and enforce contracts that are unconscionable, right? And so I wonder whether this same reasoning that Western has can also apply to the application of public policy. So it's not so much that like it's not so much they're saying people can't do this. It's almost like a state action question in that the court can't involve themselves in this, and that's how that's how sort of some kind of horizontal effect of public values works in the U.S. to some extent.
I think, and I actually wrote a paper on this, so if you're interested, it's on my SSRN page. It's called Welcome the Newest Unworthy Donor. And my opinion on this is that they just did not need to go to court to do this. They could have done so many other things. They could have put out their own publication on Kenneth Hilborn saying, this is the kind of guy he was, and we're not happy with this. But his gift is allowing people to study history. But for your information, this is what he believed. We don't believe this. Like, there's so many things they could have done as an institution rather than, quite frankly, abuse trust law and sort of cheapen it and cheapen actions that I think legitimately could be brought through the doctrine of CPRE, like the Canada Trust Co. I don't think it's like completely on parallel with the Supreme Court of the United States decision and not wanting to be associated with something, because the Supreme Court didn't want to enforce a restrictive covenant, right? This is not the same thing. This is the university accepting $1 million gift. And then, you know, most people don't even know who Kenneth Hill, if it was like, not to be crass, but called the Hitler scholarships, I think then that would be more on par with what you're saying. But, you know, this didn't even come to light until 3 years after they were administering this scholarship. And it's because of 2 online articles that academics wrote about him, and they still, I mean, the history department should have known this about him. No one said anything. They had to convene a board of a whole bunch of people to study these 2 online articles. So I think it's an interesting point. I don't know if it's applicable here.
Okay, thank you, Jane. And Adam has left some additional thoughts in the chat.
Are they angry? I haven't looked at them yet.
Adam, I'll let you refer really
I'm
quickly.
building a head of steam towards anger. No, not at all. Listen, Jane, you and I agree on the Hilborn thing. I think that unconditional scholarship just with a name attached to it, I suspect, I don't want to take for granted, I don't suspect that we're the only 2 people in this conversation who are mildly worried about a university that takes $1 million and then besmirches the donor's name with an unconditional scholarship. That again, I'm no advocate for Hilborn. I know nothing about him. But that strikes me as deeply problematic. It's an unconditional scholarship. Academic merit was the only criterion. What, right? And if I was Western, I would have given the scholarship to DEI scholars. Like, how about that as a remedy rather than what they did? Anyway, so much to say. Good chat, everybody. Thank you.
Yes, thank you very much, Jane. And thanks to everybody for the really good Q&A. Hopefully it was helpful for you. We'll end it there and hopefully see you at the next session.
Yes, thank you so much, Anthony. Thank you, everybody, for coming.
Thank
Cheers.
you.
Thank you.
I'm going to send you an email.
Okay, bye.
Thank you.